Your Honor, this is David Chesnoff. I'm with Mr. Schonfeld on this, but Mr. Schonfeld is going to be doing the presentation.
Oh, so you're just going to be listening in?
Yeah, yes, if I can control myself.
Okay.
Thank you.
Thank you. Okay, there's a couple matters I want to spend some time on, and the first one is Collins versus Las Vegas Justice Court, Department 13, and the Honorable Suzan Baucum, case number A21-838-502-W. Would counsel who's present please identify yourselves for the record? Let's start with the petitioner.
Earl. Good morning, Your Honor. Richard Schonfeld and David Chesnoff on behalf of petitioner Zaon Collins, who is also appearing via Blue Jeans app.
Okay, and counsel who's present?
Eric Baumann with the Clark County District Attorney's Office, real party and interest for the respondent.
Okay, and this is the petition for writ of mandamus or prohibition, and I have read the papers, so Mr. Schonfeld, are you going to be arguing?
I am, Your Honor. May I begin?
Yes, absolutely, and now you please take into consideration, I have read the papers, and I understand that the state's position is the difference between this case and some that you guys have cited is that it appeared to me, at least, and maybe I got the procedural facts wrong, that the state was proceeding basically on two different fronts. One with a criminal complaint in justice court, and the other by way of grand jury indictment where they got the no bill on the DUI, but a true bill with respect to the reckless driving. And yes, that they decided to go ahead and dismiss the reckless and just proceed on the criminal complaint, which is already filed in justice court.
Yes, Your Honor, that's factually accurate in terms of the procedural history. So what we have to look at is under what basis does the state have the ability to get a grand jury indictment in the district court, which obviously is a court of higher jurisdiction, dismiss that over our objection, and then go back for effectively a redo as it relates to the DUI that had a no bill and proceed in a lower court of jurisdiction on the reckless driving after it has already been dismissed from a higher jurisdiction? And the answer is there's no authority for the state to do that. And the analysis begins with statutorily NRS 178.562. And what NRS 178.562 says is that except as otherwise provided in NRS 174.085, an order for the dismissal of an action is a bar to another prosecution for the same offense. So you start with the premise that once you dismiss, you are barred from prosecuting for the same offense. And then you look to the exceptions.
I'm sorry, I don't have your brief right in front of me. It's on the screen. What was the statute number again?
It's NRS 178.562.
Okay, I'm there.
And so effectively, as I stated, that's the starting point. Once you dismiss a case, you can't prosecute the same case unless you meet one of the exceptions. So the exceptions are those found in NRS 174.085. And there's two sections that could apply, but in reality, only one would. So the first section would be 5. Section 5 says a prosecuting attorney, in a case that the prosecuting attorney has initiated, may voluntarily dismiss a complaint, A, before a preliminary hearing, if the crime with which the defendant is charged is a felony or gross misdemeanor, B, before the trial, if the crime with which the defendant charged is a misdemeanor, without prejudice to filing another complaint. Well, that's not what happened here. We have the state going to the district court, securing an indictment and dismissing the indictment, and now wanting to prosecute in a court of lower jurisdiction. So those exceptions don't apply. We then look to subsection 7. And subsection 7 says the prosecuting attorney, in a case that the prosecuting attorney has initiated, may voluntarily dismiss an indictment or information before the actual arrest or incarceration of the defendant without prejudice to the right to bring another indictment or information. However, after the arrest or incarceration of the defendant, it can only be dismissed with leave of the court, and there has to be good cause shown and written findings. So what we have is you can dismiss a complaint and refile a complaint and proceed. You can dismiss an information or indictment and refile the information or indictment, assuming the person hasn't been arrested, and proceed. Or if the person has been arrested, you can refile an indictment or information with leave of the court and good cause shown. What we have here is dismiss an indictment and proceed on a complaint. Nowhere is there a single authority, statutorily or case law, that says you can do that. And what the state does is relies upon exclusively the case of Thompson versus State. And in Thompson versus State, we have just the situation that I described, where the state had a criminal complaint, dismissed it, went to the district court, got an indictment. Let me rephrase that. In that case, what happened was the state had a criminal prosecution commenced by a complaint, which as a result of a preliminary hearing resulted in the bind over and the filing of an information. Thereafter, they get an indictment and they dismiss the information. And the person complains that because you had an information pending and then secured an indictment, both in the same court of jurisdiction, when you dismiss the information, that is a bar to continue prosecution because you dismissed the case in district court. And the court said, no, you can have two sets or forms or mechanisms of which to prosecute. They called it dual prosecutions. Again, that is not what we have here. We don't have dismiss in district court, refile in district court. We don't have dismiss in justice court, refile in justice court. We have dismiss in district court, higher jurisdiction, and want to come back to justice court for a redo. And what the court did in the Thompson case is looked at the history in Nevada that allowed for these so-called dual prosecutions. And in looking at the history, the court relied heavily upon the Turpin case. And so when we look at the Turpin case, I want to read one part, and it's very short. What the court says is Intellis, T-E-L-L-I-S, Hall, and Simpson, which were the three cases that the court was relying upon for permitting dual prosecution. The prior proceedings by which the prosecution had been commenced were dismissed by the state after the grand jury indictment had been returned. The court was referring to having a complaint in justice court, doing the Markham notice, going to the grand jury, getting an indictment. And in those three cases, which were the predicates to the Thompson case, the complaint was, how can you have a criminal complaint in justice court and then get an indictment in district court? You're prosecuting me in two forums. And the court said that is okay because then they dismissed the complaint in justice court. And that's expressly what the court referenced in the Turpin case, where they said, in Tellis, Hall, and Simpson, the prior proceedings by which the prosecution had been commenced were dismissed by the state after the grand jury indictment had been returned. So then you get to the Thompson case, the exclusive authority that both the justice court and the state rely upon, and Thompson looks at Turpin, which, as I just stated, analyzed those three prior cases and says dual prosecutions are okay. But again, in the analysis in the Thompson case, it was the same thing. Two prosecutions in one forum. It did not address justice court to district court and then dismiss district court and try for a redo in justice court. There is not, again, a single authority that authorizes that. So when you start with the statutory...
Mr. Schonfeld, I do have a question. I have not seen the complaint in justice court. Was it the same as what was in district court, or was it lesser charges maybe?
The complaint in justice court was one count of DUI resulting in substantial bodily harm or death and one count of reckless driving resulting in substantial bodily harm or death. When they went to the grand jury, they attempted to indict on both of those same counts. The grand jury no billed on the DUI with substantial bodily harm or death, and true billed on the reckless driving. And then at the return, the state moves to dismiss. Mr. Chesnoff and I objected, and the judge granted the dismissal. And now the state wants to go back to Justice Court on the very two charges that it pursued at the grand jury, one of which they succeeded and then dismissed in the court of higher jurisdiction.
Okay, thank you.
So, Your Honor, the last statute that applies to this is NRS 178.554. And what that says is that the district attorney, in cases that are initiated by the district attorney, may, by leave of court, file a dismissal of an indictment, information, or complaint, and the prosecution thereupon shall terminate. Such a dismissal may not be filed during the trial without the consent of the defendant. So you're starting with the two start points. One, when you dismiss, prosecution is terminated. And two, when you dismiss, it's a bar to refiling or re-prosecution unless it meets one of those exceptions in NRS 174.085, and as explained, it doesn't, because the two exceptions are exactly what I've been describing. Justice court to justice court, district court to district court. And even the Thompson case, again, the exclusive authority relied upon, was district court to district court. Information filed, indictment filed, both in the same court, information dismissed. Court says it was okay to have those dual prosecutions. Has nothing to do with what amounts here to forum shopping. And in my moving papers, I described it as gamesmanship, which is a layperson's description of it. So instead, I'd like to give it the legal description. And we find that in Lamb versus State, and State versus Lamb. And what State versus Lamb says is that when the state is consciously indifferent to procedural rules affecting a defendant's rights, it should be a bar from recharging the defendant. And that's what we have here, Your Honor. The state chose, which they had a right to do, to go to the grand jury. We presented them with exculpatory evidence that under Nevada law, they have an obligation to present. They presented that exculpatory evidence, and as a result, the grand jury elected not to charge Mr. Collins with the DUI aspect of the case and charged Mr. Collins with the reckless driving aspect of the case. And the state does not get to now go to the court of lower jurisdiction for a redo. And that's what they're attempting to do in violation of the case law and statutory authority cited. Your Honor, shifting to the next issue, which is the law that applies to the case, if in fact the case were to proceed. It's a significant issue because in this case, the allegations are that Mr. Collins had 3 nanograms per milliliter of THC in his blood. The statutory per se level prior to July of this year was 2 nanograms per milliliter. We cited at length the legislative history as to how they came up with the 2 nanograms per milliliter 20 years ago. And what it is that 2 nanograms per milliliter is the lowest possible threshold that can be detected. You can't detect less than 2 nanograms per milliliter. So they effectively arbitrarily chose that amount. Well, this is the amount that we could detect, so let's start with that. But what happened, and by the way, the 3 nanograms per milliliter alleged in this case, there's a margin of error of 0.6. So that means that Mr. Collins, according to the state, could have been at a 2.4 nanogram per milliliter level at the time that his blood was drawn. So what happens from there? Recognizing with time and science that the 2 nanograms per milliliter is arbitrary, they go to the legislature, and in July, the statute that Mr. Collins is charged with is modified. So the modification is one-fold instead of two-fold. And what I mean by that is they modified the statute so that for misdemeanor offenders, the state has the additional burden of proving that the marijuana content caused the driver to be impaired. So if somebody consumes marijuana and drives and gets pulled over, they can't just take the person's blood and say you are over 2 nanograms per milliliter, or in this case, they would allege you are at 3 nanograms per milliliter and therefore it's a DUI. Instead, they actually have to prove that the 3 nanograms per milliliter caused that driver to be impaired. So it's an additional burden of proof on the state to establish a DUI. However, that only applied to misdemeanor offenders. In the same statute, there's only one statute, the legislature decided that for a felony offense, you could still be found guilty on the per se level of 2 nanograms per milliliter. That makes absolutely no sense. If you think about it, misdemeanor offenders are subject to lesser consequences as a result of a conviction, and the state has a higher burden of proof. Felony offenders are subject to far more significant consequences, and the state has a lesser burden of proof. And this situation was analyzed in a case by the Nevada Supreme Court called DeRosa, and that's found at 115 Nevada 225. It's a 1999 case. In that case, the Supreme Court was addressing a circumstance very similar. And what the Supreme Court said in that case is that the Equal Protection Clause of the Constitution is essentially a direction that all persons similarly situated should be treated alike. The Equal Protection Clause requires that state laws which provide different treatment to different classes of people have a rational basis to a legitimate government interest. And here's the important part. As long as Nevada's statutory scheme sufficiently protects constitutional rights of a misdemeanor defendant, the fact that it affords the misdemeanor defendant less procedural protection than a felony defendant is not of constitutional moment. Felony defendants face a greater loss of liberty than misdemeanor defendants. Convicted felons face incarceration in the state prison rather than county jail, loss of civil rights, more severe subsequent sentencing enhancements, longer periods of incarceration, and higher fines. Affording misdemeanor defendants less procedural protection than felony defendants is rational. It's a rational means to a legitimate government objective. In that case, they were analyzing the statute that allows the state to use an affidavit instead of live testimony from a chemist in a misdemeanor DUI case. But in felony cases, the state had to present live witnesses. So the misdemeanor defendants complained and said felony defendants are getting more procedural protections than we are, and I just read what the Supreme Court held. But when you look at that, the opposite is what is occurring here. The statute now affords misdemeanor defendants greater procedural protections, and it's more than just procedure, than felony defendants. Clearly unconstitutional and clearly not rationally related to a legitimate governmental interest. And now take it one step further, and this is the void for vagueness argument. If somebody consumes marijuana today and 2 days from now, even though there is a high likelihood they will have THC in their system, they say to themselves, I don't feel impaired, I'm going to drive. And they get pulled over. Under the statute as it exists now, they did not commit a crime. Because they drove, they got pulled over, and there were no signs of impairment. Hypothetical number 2, exact same situation. Person consumes marijuana today, 2 days from now they drive, so far not illegal because they're not impaired, but then they get into an accident that causes substantial bodily harm or death. Now all of a sudden, the conduct from hypothetical 1, which was perfectly legal under the statute, becomes illegal as a result of the consequence, the accident, as opposed to the conduct at issue. How is a person of rational intelligence supposed to know what is illegal and what isn't, when the very same actions on their part were perfectly legal, but for the end result, the accident and the injury? It is 100% unconstitutional statute. So the state's argument as to the statute, they really don't argue the constitutionality. Instead, they say because the statute was implemented in July of 2021, and the alleged offense at issue in this case occurred or was charged in January of 2021, the new law does not apply, and I'm using quotes, retroactively. This is not an issue of retroactive application. Rather, what it is an issue of due process. And so we cited 3 cases in our brief as it relates to the fact that prior to a conviction becoming final, it is if a new law passes and it provides a defendant with more protection, it is not an issue of retroactivity, it is an issue of due process. So the two cases that come from the U.S. Supreme Court are Bunkley versus Florida, 123 Supreme Court 2020, and the other one is Fiore versus White, 121 Supreme Court 712. Both of those cases stand for the notion that it is a due process violation if prior to a conviction becoming final, the law changes to afford the person more protection. Most significant, the Nevada Supreme Court has adopted those holdings, and that's in the Nika versus State case, 124 Nevada 1272, where the Nevada Supreme Court said, the United States Supreme Court has indicated that for purposes of due process, the relevant consideration is not just whether the law changed, but also when the law changed. Thus, if the law changed to narrow the scope of a criminal statute before a defendant's conviction became final, then due process requires that that change be applied to that defendant. So we have two U.S. Supreme Court cases and one Nevada Supreme Court case on point, the Nevada one. On point, adopted the holdings in the U.S. Supreme Court cases and expressly stated that if the law changes before the conviction is final, it applies. So we have a law that applies, and that law is unconstitutional. And as a result, the court has to find that the law is unconstitutional for Mr. Collins, regardless of the fact that the state would be pursuing Mr. Collins under the second part of the statute. It is all one statute, and that one statute was modified to provide criminal defendants with additional protections. Therefore, it applies to Mr. Collins. Now that it applies to Mr. Collins, the court must find that the statute is unconstitutional because it is not affording Mr. Collins, a felony defendant, with the same protections being afforded to a misdemeanor defendant. So, Your Honor, the first request for relief is that the case be, well, effectively we're asking the court to issue a writ of prohibition as it relates to the state proceeding on the DUI and reckless driving in the Justice Court. And we, if that is not granted, are asking for the court to enter a ruling that the Justice Court must apply the law as provided for in July of 2021 to Mr. Collins' case, and that that law is unconstitutional as it relates to the felony proceeding, not requiring that the state prove impairment. And unless there's questions, Your Honor, I'll pass it off to Mr. Baumann.
The court will take this matter under submission.
This is the time set for your hearing on custody.
Don't unpack. That's not what the Jay's hearing's for.
The likely result of that is you will be remanded into custody.
Okay, and are you opposing that?
judges?
No.
That's not a whole bunch of Nevada judges.
Our Nevada judges.
I'm just kidding you. I might give you a hard time. All right, go ahead.
The court has a few comments before we begin.
We are on the record in the matter, case D-505.
Okay, counsel.
Your Honor, I believe that we're able to lay out our position in some detail in our pleading, so I won't burden the court with going through the whole thing. If I could start with the second argument first, just because it's fresher in my mind. I think it's
Counsel, would you do me a favor? You're masked up, and it's reverberating in your mask, and you are far away from anybody in this courtroom. Could you take that off for me? Just because...
I would be thrilled to. Your Honor.
Okay.
Thank you. I think the important distinction in the cases of Fiore and Bunkley that are relied upon by the petitioners, that they both involve cases where a criminal statute wasn't changed. The statute itself was not amended between one point and another. What happened was that before the convictions were final, an appellate court took a look at the statute and had an interpretation of it that was different than the theory under which those individuals were prosecuted. Therefore, the idea is that when the appellate court says, this is what that statute says, then that means this is what that statute always said. So therefore, the state couldn't say, well, because that interpretation of the statute didn't exist at the time, we're still free to go ahead with the prosecution. What we have is something different here. There's no argument that an appellate court changed an interpretation of the statute in the case before the court now. What there is that the state legislature actually went and made an amendment to the statute after the offense was committed in this case. That law did not exist at the time that Mr. Collins committed his alleged offense. Therefore, I think that's an important distinction that although counsel for the petitioner would say it's not the case, it's the state's position that what petitioner is asking is actually to make that statutory modification made by the legislature retroactive and force us to proceed under a statute that didn't exist at the time the offense was committed. So that's more or less the entirety of our argument against that.
Does the retroactivity go away, though, if he hasn't been tried yet? So...
Yes, no. But he's charged under the law as it existed at the time the crime was committed. There are prosecutions that may go on for upwards of almost a decade in some of our cases, and there will be changes made in the law across that time, and the state is not forced to go back and apply every amendment to the law or change in the law that may have occurred over that period of time. We have cold cases that may be many decades old where we proceed under the law as it existed at the time the offense was committed. And that's simply the state's position here, is that granted it was closer in time, it was a matter of months, not a matter of decades, but that is a distinction without a difference for this analysis, that the law that existed at the time the offense was committed is what the state must proceed under. Likewise, if we were in a different position and let's say the law made it easier for the state to prosecute defendants by a statutory change that was made afterwards, we don't get to go back and bootstrap that to the time that the defendant committed his offense. We're stuck with the law as it was at the time the offense was committed. And the state's position is that is what the court should find. Therefore, the analysis as to the new statutory change, which petitioner put forth eloquently, is just simply irrelevant to this case. He's arguing with a statute that the defendant is not being prosecuted under. As to the vagueness argument, I think we lay that out pretty well, and we rely upon Williams versus State, the 2002 case, which addressed this statute in particular and said that the language in the statute was adequate so that an individual had adequate knowledge of whether they might be in violation of the law. Person of ordinary intelligence has adequate notice of the meaning of marijuana and that marijuana metabolites are those metabolites that result from ingesting marijuana. And a person of ordinary intelligence could reason that consumption of marijuana could result in the prescribed level, that being the 2 nanograms per milliliter. And in so finding, that statute was held to be valid and not void for vagueness. I would return now to what I'd call the procedural argument. And the state just simply, I would note that in petitioner's argument that he made today, and he referred on a number of occasions to recharging, and that's not what happened here. The defendant stood charged in justice court by means of criminal complaint. At the time the state went to the grand jury, defendant was still stood charged in justice court by means of criminal complaint. When the no bill and the true bill on the 2 different charges was obtained, and we went before the district court and moved to dismiss that indictment, the defendant still identically stood charged in justice court by means of criminal complaint. And this is what was allowed for on Thompson. There can be 2 parallel prosecutions, 2 parallel tracks of prosecution without prejudicing the defendant, and the state can choose which one it wants to proceed under.
I got a question now. From what I got from Mr. Schonfeld, the difference in Thompson is that you had 2 tracks in district court, and that this is different because you got 2 different courts.
It's just simply the state's position that that's not different, that there's no prejudice to the defendant. The defendant's not being recharged. If we were in a position where, let's say the state got its indictment, did what it would typically do when it gets an indictment, go back to justice court, we have to have another hearing where we formally move to dismiss the criminal complaint, then went up to district court and that said, you know what, we don't like the indictment, we dismissed it, now we're going to go refile the whole thing in justice court. I'm not saying I would cede the argument, but I would say that is a different argument. What occurred here is that there were 2 parallel tracks of prosecution. The state just decided to proceed under one rather than the other, and that the distinction between justice court and district court is unimportant to the analysis.
Okay, thank you.
I'll submit on it.
Okay. Mr. Schonfeld, it's your petition. You get the last word.
Thank you. I won't be repetitive.
I'm interested to hear what you have to say, sir.
Thank you. Your Honor, I'll be brief. In terms of the statutory change, to suggest that the statute can be changed before a person has gone to trial and not provide those additional safeguards, additional burdens on the prosecution to a criminal defendant is completely contrary to the law that I cited. And a good exemplification of that would be if Mr. Collins is charged today with this offense and tomorrow the law changes and says this is no longer criminal, it is clear that the due process clause would no longer allow the state to prosecute Mr. Collins because what he would have been accused of would no longer be criminal. In this case, the elements of criminality have changed and Mr. Collins is entitled to the benefits, the procedural protections that are afforded to him under the new law. So the state's position that because the case was already charged, he doesn't get the benefit of the new law is wrong. And for the state to liken it to a situation where if the law got easier for them after a person had been charged, they wouldn't get the easier track is a totally different analysis under the ex post facto clause. The criminal defendants are the ones under the constitutional that are entitled to the greatest protection under the law because of the significant consequences of a conviction. So it is Mr. Collins that is entitled to the benefit of those protections. The state doesn't get to have an easier job if the statute gets amended and makes it easier for them. Totally different analysis. And with that, Your Honor, I will submit it.
I've got a question for you that the state had indicated that there is no difference with the dual tracks in the two different courtrooms, and that it's, well, he didn't quite say it, or maybe he did, but I kind of got the impression that they filed the criminal complaint in justice court originally, and then they decided that they were going to up the stakes, so to speak, and go to district court to get the grand jury indictment. It didn't work out, so then they're punting and going back to their criminal complaint in justice court is kind of what I'm getting. And that if they had been successful with respect to the grand jury, that they would have dismissed the criminal complaint and just proceeded in district court. So I guess I'm having trouble understanding the difference. Why is it that they can dismiss the criminal complaint in justice court, proceed in district court, but they can't, if they have the criminal complaint already in place, dismiss what's going on in the district court and go back to justice court?
And Your Honor, the reasoning behind that is twofold. Number one, I'll give the logical aspect, and then two, I'll cite the cases. So the logical aspect of that is that you're in a court of lower jurisdiction where the finding would simply be probable cause or slight or marginal evidence that the person committed the offense, and therefore it gets bound up to district court, the court of higher jurisdiction. There is no logic in being in a court of higher jurisdiction to then go back to the court of lower jurisdiction. For example, when someone waives their preliminary hearing to enter a resolution in district court, they are admonished that if you change your mind in district court, you don't get to come back to justice court for a preliminary hearing. You are already in the court of higher jurisdiction. So that's the logic behind it. But the law behind it is that which is found in the Thompson case, which the state relies upon, which relies upon Turpin, which has the Tellis, Hall, and Simpson, where it says the prior proceedings by which the prosecution has been commenced in those cases were dismissed by the state after the grand jury indictment had been returned. So the Nevada Supreme Court has expressly said it is okay to have a criminal complaint pending in justice court, go to the grand jury and get a probable cause finding to take the case to district court, and then dismiss the lower court proceedings. There are 4 cases that say that is okay. The state acknowledged there isn't a single case that says it is okay to have a case in the higher court of jurisdiction and dismiss it to proceed on the criminal complaint in justice court. And instead, the state wants you to, by analogy, say that is okay based on the Tellis, Hall, and Simpson and Thompson case that only address the circumstance I described. Indictment returned, criminal complaint dismissed. Nowhere is there a case where indictment dismissed, let's go to a prelim in justice court. Hasn't happened? Well, I know of no situation where it's happened, but the fact that there isn't a single case that talks about that just shows the court how outrageous it is. And for the state to want the court to rely upon analogy as opposed to actual authority doesn't cut it when we have all of those foundational statutes that I started with that talk about when you dismiss, it's over unless you meet an exception. And there's no exception under the statute, no exception under any of the cases, because there's nothing that says you can get an indictment, dismiss it, and go back to justice court. It only says you can get an indictment while you have a complaint in justice court pending, and then you dismiss that complaint. That's not what happened here.
Okay, Mr. Schonfeld, assuming I deny the petition, procedurally, what happens from justice court with a criminal complaint? There's a prelim, right?
Yes.
Okay. And then there's a determination whether or not there's probable cause, and then it goes back up to district court, right?
Correct. And let me tell you why that is problematic. Because when it gets back up to district court, they will file a criminal information. When a criminal complaint gets bound over to district court, they file a criminal information. Right. And that takes us back to NRS 178.554. No, that's not the one. Hang on one second. 170. It's 174.085 sub 7 that says a prosecuting attorney in a case may voluntarily dismiss an indictment or information before the arrest or incarceration of a defendant without prejudice to bringing another, not what happened here. After the arrest or incarceration, the prosecuting attorney may voluntarily dismiss an indictment or information without prejudice to the right to bring another indictment or information only upon good cause shown to the court and upon written findings and a court order to that effect. So if we go to a prelim and it gets bound over, they're going to file an information in district court after having dismissed one without having the good cause shown and written findings and court order permitting them to do that, because Mr. Collins has already been arrested in this case. So it's a violation of the very statute which the state originally relied upon, NRS 174.085.
Let me ask the prosecutor, what's your response to that? By the way, you're going to get the last word, Mr. Schonfeld.
He usually does. Court's indulgence. I would again note the language says without prejudice to the right to file another complaint. The state is not filing another complaint here. The complaint already exists. It's pending against the defendant. It has been since the moment it was first filed. It was not dismissed, and we're not refiling.
Your Honor, that doesn't address NRS 174.085 subsection 7, which is the court's question. That if you go through with
this is what it says, and I've got the book right in front of me too. So we're not talking about filing another complaint. We're talking about the prosecuting attorney may, after the arrest or incarceration of the defendant, the prosecuting attorney may voluntarily dismiss an indictment or information without prejudice to the right to bring another indictment or information only upon good cause shown to the court and upon written findings and a court order to that effect.
Your Honor, it's the state's position that the path of prosecution already existed and that we're not proceeding anew. And that's the entirety of the state's position. And we rely upon Thompson to say that the state is permitted to do that.
Okay, and that's the good cause shown?
It's the state's position that that clause was not triggered, and the district court did not find that good cause had to be shown at that time. Therefore, it was not.
Well, and then an information automatically happens, doesn't it, if the state acquires the hurdle of the probable cause component of the criminal complaint?
Correct.
You know, this is a real close one for me. And by the way, it's also a very interesting point. What's your anything else you'd like to say, Mr. Schonfeld?
Your Honor, I'm just going to note that the state didn't answer the court's question, and it's squarely within number 7 of NRS 174.085. If we go to a prelim and it gets bound over, the state has to file an information. According to NRS 174.085 subsection 7, the state cannot file that information without effectively leave of the court with good cause shown and written findings in a court order. What's the good cause here? That we decided to take the case to the grand jury because we didn't want to allow defendant's counsel to cross-examine our witnesses because this case is so weak. And I'm saying that in terms of the 3 nanograms per milliliter alleged, with a 0.6 nanogram margin of error, which puts it at 2.4. And now in hindsight, the Nevada legislature has effectively said that that's weak because they've changed the law to require evidence of impairment. So we go to the grand jury, being the state, because we don't want the defendant to be able to cross-examine these witnesses and bring out all of those deficiencies in the prosecution in terms of impairment. Grand jury, because we asked the state, and they were obligated to present the exculpatory evidence, says no bill on the DUI because it's not there. Indictment gets returned, we appear, we object to the state being able to dismiss it The state insists upon dismissing it, it gets dismissed. No written findings regarding good cause, not even an argument regarding good cause. So now we look at the statute, subsection 7. Was there an indictment in district court? Of course, we know that. Was the indictment dismissed in district court? Of course, we know that. If he gets bound over, Mr. Collins, at a preliminary hearing, will the state be filing another information in district court? Yes. Does the state have good cause because they wanted a redo, because they didn't get the results they wanted at the grand jury? That's not good cause. Does the state have written findings from the district court saying that they're allowed to proceed because there is good cause? No. How do they get to file that information in district court after a preliminary hearing? They don't. Fits squarely within the prohibition under NRS 174.085 subsection 7.
Okay. I'm going to tell you both. You've done an excellent job, both of you, on this issue. It's very interesting to me. But at this point, we do not have an indictment or information filed again after the indictment or the indictment was dismissed. So we haven't gotten there yet. And subsection 7 doesn't talk about criminal complaint, which I appreciate is the precursor to an information being filed if probable cause is shown. And I would assume at that point, even then, the state has got the discretion whether they're going to even file the information. To me, that this subsection 7 would be triggered once an information is filed, and it hasn't been yet. I think the matter needs to proceed in justice court. So I am going to go ahead and deny the petition for writ of mandamus. It can proceed in justice court with respect to making a finding whether there is probable cause. I think it's really close, Mr. Schonfeld. I'm not going to make a finding that the statutes are unconstitutional. So I'm not going to make instruction to the justice court on that.
Your Honor,
yes.
What's the court's finding as to whether or not the new statute applies to this case that is still pending?
In my view, it does not. It would be a retroactive trigger, and I don't think that it is. You certainly have an issue to take up to the Nevada Supreme Court, and maybe this will be the one case. And I will say you did a splendid job, and it was very close for me, but I am going to deny your petition. But I want to thank you very much.
Thank you, Your Honor.
Okay. And will the state provide me a proposed order, pass it by Mr. Schonfeld, for him to approve as to form and content, not that you agree with me, but that you at least appreciate that that was my ruling?
Yes.
All right, and I want to thank you both again.
Thank you, Your Honor.